So welcome to Estate Planning 101, which is being presented by attorney Allison Poirier of KKC Law, which is Kahan, Kerensky, Caposella. This presentation is sponsored by the Carmen Community Funeral Homes, who we'd like to thank for being one of our gold sponsors. So if you want to speak with attorney Poirier or Carmen, they are in this room, right behind the partition, not in the gymnasium. Attorney Poirier has been an attorney with KKC Law for over 10 years. She's past president of the Tolland County Bar Association and focuses on estate planning, probate, and elder law. And you can watch her YouTube channel for more information. And what is the name of that?
What's the YouTube channel?
Yeah.
Oh, it's Kahan, Kerensky, Caposella.
Kahan, Kerensky, Caposella. It's in your programs. Okay? Without further ado, attorney Poirier.
But today my goal is just to give a lot of just very general basic estate planning information. So things like about basics of what a will is, trusts, what is probate. If at any point anybody has questions, please feel free to interrupt. I find these presentations go a lot better when they're interactive. But to get started, so why do you do estate planning? I'm sure this comes really as no surprise to anybody. But you can say where you want your assets to go when you pass away. While the state does have default rules, which are called the laws of intestacy, you never want to rely on the default rules. So it's always best to have a document saying, here's where I intend for my assets to pass. You can also, depending on the way you set it up, make sure you're minimizing the paperwork and the administration that you're leaving behind for your loved ones who are actually going to have to handle settling your estate. You get to pick who that person is to make sure it's the right person doing those things, so it actually gets done, and it gets done in the way you wanted it to get done. And also, too, there's with estate planning, a topic I'm not going to touch too much on today, just because I understand one of our other presenters either has or is going to talk about this topic. But with a good estate plan, you can also do a little bit of asset protection as well. So if your concern is not only, I want to make the administration of my estate easier, but maybe I have concerns about protecting my assets for long-term care costs and things like that, a good plan can address those concerns as well. So first and foremost, what happens to my assets when I pass away? And the simple answer is it depends on how you own your assets. So I love using this flow chart here, and also too, I know the print might be a little small. I do have handouts of the presentation, so anybody who wants to take a copy home with them after, please just come up and see me. But the chart here is designed to show you that there's really kind of 4 different ways to own your things. So depending on which of these boxes you fall in, that's what's going to determine, do I have to go through probate or not, essentially. The first column, all the way over on the left-hand side there, is for any assets that are owned jointly in survivorship. So with married couples, we tend to see a lot of joint assets. The house is joint, the bank accounts are joint. But even between parents, as you get older, sometimes you're adding your kids on, as joint on the checking accounts. They're stepping in and helping you pay the bills, things like that. But the simple answer, so to say you have any assets that fall in that first column that are jointly owned, when you pass away, those assets get to pass automatically to the surviving co-owner. They don't have to go under the will, they don't have to pass through probate, so it can make things a lot simpler. The second column there, which is for any assets that are going to pass under a beneficiary designation. Some of the most common examples we see are things like retirement accounts, life insurance policies, annuities, pretty much any type of financial account that you have that when you set up, you filled out that beneficiary form that says, well, when I pass, it goes to my spouse. When we're both passed, maybe it goes to the kids. So any accounts where you've put a beneficiary designation on like that, those assets also just get to pass directly to your named beneficiary when you pass away. And again, no need to go under the will, no need to go through probate. And I'm even going to stop there for a second. So a lot of times I meet with people who have never really done estate planning, or unfortunately maybe a loved one has passed who never did estate planning. And every now and again, it might be okay because they may have had all of their assets jointly owned and all of their assets with beneficiary designations, which means even without any formal documents in place, they still manage to have all of their assets bypass probate, simply because they were aware of how they owned their things. But it doesn't always work out that way. So I don't want to say don't just rely on that, because that necessarily doesn't work 100% of the time. Because there's always this third column here, which is for any assets that you own solely in your own name. Those are the assets that do have to go through probate when you pass away. And actually, I'll take a poll of the audience. Who here has a good probate story? No, yeah, I didn't expect to get any. Because with all due respect to our local probate courts, who are absolutely fabulous, probate is not necessarily a simple process. I have yet to have a single person walk into my office and say, Allison, I want to make sure my assets go through probate. It just doesn't happen. Not that probate necessarily is bad, but it just takes a long time. Most estates that we help people with take about a year from start to finish. And I mean, that's normal. That's best case. We've met all the deadlines. There's no issues. So if there's other things going on in the estate, beneficiaries who are unhappy, complicated assets, things like that, it can make the process even take longer. So that's why that third column, I kind of, for lack of a better description, I'll call that the bad column. We want to keep assets solely out of your name when you pass, because if we can, that means those assets don't have to pass through probate. The fourth column on the far right-hand side is for a revocable trust, or sometimes called a living trust. And trusts are simply another way to own your assets. And I'm going to explain a little bit more about trusts in a minute, but just for purposes of this slide, assets owned in trust don't have to go through probate when you pass away. So if you're, again, your primary goal is, I want to make sure my assets don't have to go through probate when I pass, and maybe for some reason beneficiary designations or joint ownership isn't quite a good fit, a revocable trust might be another option for you. So what is probate? And I touched on this a little bit, but just to get in a little bit more detail, because a lot of times people also know, well, probate is bad, probate takes a long time, but then you ask them, well, what does probate do? And we kind of say, well, I don't know, I just know I'm not supposed to go there. But probate really, it serves a valid purpose. So it's there to make sure, and the probate court does do a whole lot of things in addition to what we call decedent's estates. But when you're there in the context of somebody's passed away, the whole purpose of probate is to make sure the assets get to where they're supposed to go. So it's the court process to make sure everything that's supposed to happen happens. It's also going to provide kind of the legal paper trail that show ownership of your assets have transitioned over to the person that you said you want them to get them. Because even if a will says, when I die, everything goes to my spouse, or when we're both gone, maybe everything goes to the kids. Those are the rules, but you still need the court to implement them. So it's not enough to say, I've named my spouse as the beneficiary of this. You still need to submit the will to the court needs to approve it, and then the court's going to give you the decree showing ownership is transferred from the decedent over to you. The probate process is public. If you are so inclined on Monday morning, you can go down to the probate court and say, my neighbor John Smith passed away about a year ago. I just want to see what his will says. You can get a copy. You'll probably have to pay $5 a page or so, but you can get a copy. You can get a copy of an inventory that's filed in his estate that says, here's all his assets that we're going through the probate process. It's public record. So a lot of people who say, not only do I not like the idea of dragging my things through maybe a fairly lengthy process, they say, kind of don't like the idea of everybody knowing my business, then probate avoidance might be a little bit more important to you as well. And on the timing piece, again, probate can take a while. There's a couple different types of probate processes available, and which one you have to use depends on the amount of assets that you have passing through the probate process. So there's a small estates procedure, which is if the court says, yes, okay, you have assets going through probate, but the total value of those assets is less than $40,000, they don't drag you through the whole year-long process. They cut you a break. They say there's a couple of forms you need to fill out, some information you need to provide. But the longest piece of that process is really just once you submit the paperwork, you have to wait for the court to process it. But once they do, you're done. So that's kind of more on my time frame I give there, where I say it could take 3 months. That's usually for those small estate procedures. But if this is what we call full administration, which means you have more than $40,000 worth of assets actually going through this probate process, then that's when you're going to see a year or more. So when do you need probate? And again, I apologize, I kind of covered a little bit of this, so maybe I'll get through this a little bit quickly. Assets that are individually owned do need to go through probate. But also, and as one of my clients, I thought very succinctly pointed out to me recently, there are times when you don't need to have assets go through probate, but you're still going to probate. And what it boils down to is if when you pass away or if you're the executor of the estate, the decedent had any ownership in real estate when they passed away, whether it was solely in their name, whether it was jointly with somebody else, they had any type of ownership on real estate, you're always going to have to go to probate as well, because there's going to be some forms you need to file with the court, even if there's zero individually owned assets. So even if there's zero probate assets, if there's real estate somewhere in the mix, you're going to have to go to the probate court. So I always like to make people aware of that. Excuse me? When does it need to happen? So the real filing requirement, the document that the court is looking for in the case of when there's, let's just say there was no probate assets, but you had some ownership interest in real estate. The main document that they're looking for you to file is an estate tax return. And so because Connecticut and the federal government say if you have too much money when you pass away, we get a piece. That's what the estate tax is. The good news is you have to have almost $14 million before an estate tax is due. As of January, it's been going up. You have to have over $15 million. So the end result is very, very few people are paying estate taxes. But that estate tax return has to be filed in every estate, and it has to be filed within 6 months of the date of death. So that's the deadline we're usually coming up against. All right, so the question is, I own assets here, but I also own assets in another state. Does that mean I can just do all the probate here? And unfortunately, no. So if you own property here, you own property in Texas, when you pass away, you get to do 2 probates for the price of 2. You get to do one here, you get to do one in Texas. And the reasoning why, and maybe I won't speak for every single state, because every state has slightly different probate court rules. So the ones I'm going over today are Connecticut's. But assuming that Texas has a similar system as Connecticut, it's going to mean if you have probate assets, we're doing what's called the domiciliary or primary probate here. And then if you have real estate in another state, you have to do a probate in each and every other state in which you own real estate. So if you have a property here, you have the family vacation house at the Cape, you inherited a piece from your parents down in Texas, you may be doing probate in a whole bunch of places. And maybe just one final note too, where I said with real estate and needing to file that estate tax return, the reason why is because the state of Connecticut kind of takes the point of view of, well, just in case you owe us an estate tax, we want to make sure we get paid. And the way that they do that is from the moment you pass away, they put a lien on your house for potential estate taxes. So that's why it's so important to go into the probate court to prove, unfortunately, and actually, I hope everybody has over $14 million when you pass away. I hope everybody owes an estate tax, because that is a fabulous problem to have. But usually what's happening is your executor has to go into the probate court, you file the estate tax return to say, unfortunately, there wasn't $14 million. Please release that lien for potential estate taxes off my house. And then the court will issue that release and you're all set. But it's just so important to do that, because if you ever have any plans of selling the real estate or having your beneficiary sell the real estate after you pass, they need to do this. They're not going to be able to sell the house until the state's lien for potential estate taxes is released. All right, and again, to quickly go over, because I think I've covered most of this. What does a will do? The will only comes into play when we're already in probate. Because the will itself doesn't avoid probate or keep you in probate. The rule, the state of Connecticut says just once we've already determined you have assets in probate, so we know you have individually owned assets, the role of the will is to be the instruction manual now for the probate court solely for where those individually owned assets go. That also means the will isn't going to dictate where your beneficiary designated assets go. It's also not going to touch your jointly owned assets, because those assets bypass probate, and so they bypass the will, so they're going otherwise. So one of the key things that I always stress to my clients too is I can prepare the most perfect will on the planet, but if all of your assets are passing through beneficiary designations or they're all passing through joint ownerships, there's nothing left to pass under this will. So if you want to have the will, that's all well and good, but you should also go take a look at how you own those other assets, what your beneficiary designations say, so you make sure the plan as a whole is really working together. But again, so the will say if you have assets going through probate, here's where they're supposed to go. It's going to appoint who your executor is, so who's the person that's on the hook for filing any necessary documents with the court. Again, it's also, you have to submit the will to the court and have the court approve all the distributions before those assets can actually be transferred out to the beneficiaries. If you have minor children, or if you're the guardian for minor children, the will is also where you appoint a guardian to say, if I pass away, here's who I now appoint to have the legal authority to look after my kids when I'm gone. All of that happens under the will. But what if there's no will? So if you have passed away, and despite your best efforts, you never got around to putting that will into place when you pass away, and I kind of briefly mentioned before, the state has default rules that say where your assets go. The good news is it's not going to the government. It's not going up to the governor's mansion in Hartford. They don't get your stuff. So that's the good news. But they have these rules that say, well, okay, this is kind of our best guess as to where most people would like their stuff to go if they didn't have a will. And what it kind of boils down to is your closest living relatives. If you're married, it goes to your spouse. If you're married and you have kids, there's a split between your spouse and your kids. If you're not married and you don't have kids, we go up. Basically, we can't go down your family tree, we go up your family tree. We go to your parents. If you don't have parents, we go to siblings. If we don't have siblings, we go down to nieces and nephews. Still nobody there, we go back up the family tree again. We go to grandparents, we go to aunts and uncles. We kind of search through your family and find the closest living relatives that you have, and those will be the people that ultimately take your assets. So that might work. In this chart here, kind of shows you a little bit of that, what some of those examples are depending on which living relatives that you have. But again, I'm almost reluctant to rely on the default rules, because it may sound good in theory, but in practice may not work out too well. I did have an intestate estate once where it was a fairly younger person who passed away. They had minor kids, they had a spouse. Because they had a spouse and children, the spouse and the minor kids ended up becoming joint owners of the house, because there had to be a division between the spouse and the kids. So that's why I say, in theory, it sounds good to say, oh, it all goes to my spouse, it goes to my kids, but in practice, it may not work out exactly as they intend, which is all the more reason to write a will, because then it overcomes all these default rules. All right, trusts. There is a whole lot of things you can do with trusts. Raise your hand if you've heard people say you need a trust, or your neighbor said, I got a trust, you got to get one, something like that. Anybody? Okay. Who knows what a trust does? Yep, so kind of like the same thing with probate. Everybody's kind of heard of it, but you're kind of fuzzy on, well, I'm not exactly sure what it does. And trust can do a lot of things. I kind of offhandedly always say trusts are kind of like Baskin Robbins. There's 31 different flavors. So just because somebody says, oh, I have a trust, you should get one. You might want to say, well, what were you doing with a trust? What problem were you trying to solve that you used a trust? Because your neighbor's trust may not be the same as the trust that you set up if you need a trust at all. So just be mindful of that. But generally speaking, at least for terminology's sake, there's kind of three big terms with a trust that you're going to want to know what they mean. The settlor, or sometimes also called the grantor or the donor, that's the person who creates the trust. So that's you. You're creating the trust. The trustee is the person in charge of the trust. Once the trust is set up, kind of the general reason why all trust exists is to own assets. So people put their houses in trust sometimes, or they put life insurance policies or bank accounts, or you can put a wide variety of different, a whole bunch of different types of assets in trust. But once you have assets in trust, well, somebody's got to be in charge of them. Somebody's going to have legal ability to manage them or sell them or do what needs to be done. And that person's the trustee. The beneficiary, as I'm sure everybody probably knows this one. This is the person that's actually entitled to distribution of the assets from the trust. They're the kind of reason why, or the person that the trustee is looking out for and has to manage the assets for. With a revocable trust, which is one of the most common types of trust we use in an estate planning context, you are probably all three of these people during your lifetime. You are the creator of the trust, you are the trustee of the trust, and you're the beneficiary of the trust. Because the number one goal a lot of times with revocable trust is we just want to keep your assets from having to go through probate. So if you remember my chart a few slides ago, assets owned in trust get to bypass probate. So, but we don't want to take away control of your assets from you. They're your assets, so you should still be in charge, which is why I would say you're really filling all three of these roles. So even if you decide to put some assets into your trust and you say a year later, I want to sell that house, or I want to take this out of trust and put something else in, go ahead. There's zero restrictions, typically upon your ability to manage these types of assets, because the trust is simply designed to keep you in control during your lifetime, but keep the assets out of probate after you pass away. So what are some reasons why you might want to have a trust? I gave kind of a short list here. One, probate avoidance, but also two, sometimes these trusts continue on after you pass away. So if all we're looking for is probate avoidance to say, I love my spouse, I love my kids, I trust them to manage anything they get from me, I just don't want them to have to go through probate to get it. Maybe your trust says, when I die, my trust terminates, it goes away, everybody gets everything outright. And that's all you were looking for, so that's all the trust needed to do. But if you said, well, I'd love to leave some money behind for my grandkids, or I love my daughter, but gosh, I hate her husband, he's just gonna divorce her. Anything I leave to her is gonna go right to him. There's a whole bunch of reasons why you might not want to leave assets to people directly in their own names. And so that's when trust can be helpful too, because you can still say, well, I leave money to my daughter, but in trust. So it's still there for her. She still has access to it, but we just put a trustee in charge of it to say, this is the person that's gonna manage it for her, so she doesn't own it directly. So if she does get divorced, or I love my daughter, but she's a terrible driver, she's gonna get in a car accident and get sued one of these days. So again, the money is there for her. It's for her benefit, but legally speaking, she doesn't own it. So if she gets sued, she gets divorced, those assets are protected. Also too, when I said maybe leaving assets behind for minor beneficiaries like grandkids, it's not that you don't trust them, they're just legally not old enough to own assets. So you might want to say, I leave money behind for these people until their age 21, 25, until they're a little bit older, and then they can just get it. Because my concern is I just want them to be old enough. Also, there might be people you want to leave money to who are receiving state or federal benefits. They're getting their health insurance through, Husky, or maybe they're receiving Medicaid for long-term care purposes. So if you leave them a bunch of money, that might now all of a sudden make them ineligible to receive those benefits. Because a lot of times the more money you have, the less benefits you get. So there's also another type of trust we can set up to say, well, I still leave money behind for this person, so it's available to them, but in such a way that it's not going to impact their continued eligibility for benefits. The last one on this list is can be a fun one, depending on the situation. If it's a second marriage or a third marriage, and you have a spouse with kids from a prior relationship. So maybe it's not as simple as I leave everything to my spouse, and then when we're both done, I leave everything to the kids, because, well, gosh, okay, maybe my spouse is okay, but what if I pass away first and they get remarried after I die, and they make a will that says I leave everything to my new spouse? You've just effectively disinherited your own kids. So with trust, you can also say kind of similar thing, I leave money behind for my spouse, but in a trust. And then once my spouse is gone, I still control that at that point, whatever's left goes to my kids. So there's a whole bunch of different things that you can do with trusts, but it's good to know that that's an option out there. So depending on what you're looking to do, there's probably a trust out there that could help you with it. Oh, and my bottom bullet point on here too, revocable trusts do not provide protection from long-term care costs. There are specific types of trusts that do. Revocable trusts are not one of them. So if your goal is, I want to make sure that I don't have to spend all my money in my house and everything on, caregivers or skilled nursing facilities and leave nothing behind, it doesn't help to have your assets in a revocable trust. So please be aware of that as well. Irrevocable trusts do provide that protection, because unlike the revocable trusts, it's irrevocable. You don't get to be the trustee of this trust. You don't get to be the beneficiary of this trust. Because the reason why these trusts exist is to say, we want to separate you from control of your assets. We want to separate you from ownership of your assets. Because if you can't get at your assets, neither can the people chasing you for money. So if you needed to go into skilled nursing, after you get in a car accident and get sued, and somebody says, I want all your money, or I'm forcing you to spend down all your money, you can say, I don't own it. My irrevocable trust owns it. And I'm not the trustee. I'm not the beneficiary. That money's gone from me. It's not mine anymore. So that's where you're going to get protection with these types of trusts. The downside is, and at the risk of sounding repetitive, it's irrevocable. So once your assets go in there, once you write those rules, there's ways to potentially undo it, but the thought process is, we don't want you to undo it. We don't want you to get access again. Because again, the more access we give you to those assets, the more now those claims can potentially, your creditor claims can now potentially attack the assets in this trust. So ideally, anything that you put into an irrevocable trust, plan on never needing it back again, because that's the idea. We don't want you to have to get it back so it can stay protected. If you are doing this specifically for long-term care purposes, I'm worried I'm going to have to go into a nursing facility. I'm worried all my money is going to have to be spent down so I can get eligible for Medicaid. With the irrevocable trust, always be mindful of the fact that specifically in a Medicaid context, there's also a 5-year look back. So if you put all your assets into an irrevocable trust today, and next month you say, okay, now I'm eligible for Medicaid, the state is going to say, You have to do that at least more than 5 years prior to submitting a Medicaid application. Because that whole 5-year look back says, the state basically is saying they want you, if you can afford to pay for your care, go pay for your care. And when the money's gone, then come to us. Don't give away your stuff and then come to us with your handout. But so long as you give away your stuff more than 5 years before you're applying for the state to step in and cover your care costs, then they say it's protected. So this is the type of planning you have. It's not one of those things you can say, okay, I'm going into a nursing facility, maybe next month. I know I have enough money to pay for 6 months and I'm going to, have to go on Medicaid. Let's start looking at that irrevocable trust. At that point, it's kind of too late. So it is planning that you need to do fairly far in advance. The most common type of assets that we look at putting into these type of irrevocable trusts and trying to protect, real estate is probably the big one. Because there's a way that we can transfer your house into the trust, but still give you the right to live there, still say you have the obligation to pay the property taxes and the insurance, and all the utilities. It's called reserving you a life use or life estate. So that can be a fairly easy asset to part with, just because the way we set it up is not really going to have too much of an impact on your day-to-day life. You still get to live there, it's just your name isn't on the deed. Life insurance policies can be another common one. Also, if you just are blessed enough to have there's this cash account, there's this CD, there's this annuity, I'm not really touching it. I don't need it, and I don't foresee the need that I'm going to have to touch it. Sometimes we can put those types of assets away in a trust as well. All right. The second piece of estate planning, because primarily, or maybe again, I'll poll the audience. When I say estate planning, the very first word that comes to your mind, if this is correct, raise your hand. The very first word that comes to mind is will. Yeah. So that's why a lot of people come into my office and they start off by saying, before I even say anything, they say, Allison, I need a will. And I say, okay. And maybe you do, maybe you don't. And I walk through, what has to go through probate, and I do that whole discussion with them. But then I also say, do you know any kind of good estate plan, or what we call a comprehensive estate plan, also includes things like powers of attorney, healthcare directives, living wills, more under the umbrella of what we call incapacity planning. Because not only with a good estate plan do you want to make sure your assets get to where you said you want them to go, the way you want to get there, but God forbid something happens to you while you're still here and you're not able to do the things that you normally do for yourself. I can't get to the bank. I can't pay my bills. If you develop Alzheimer's or dementia, you can't talk to doctors and tell them what you want to happen with your care. These documents allow you to appoint someone that can legally stand in your shoes and make decisions on your behalf. Also important to note, there is no default decision maker under state law. Just because you're married, just because you have kids, does not give them the automatic right to make decisions for you, which is all the more reason why it is so important to have these documents in place. They're kind of rainy day documents. You hope to God you never need them, but if it starts raining and you need them, you're going to be grateful you already have them in the drawer and you can pull them out. With the power of attorney, that is for all things financial. If you do need somebody to pay your bills, you need somebody to sell your car, you need somebody to file your taxes, update your beneficiary designations, that all falls under the power of attorney. That's the person you appoint to make kind of any and all financial or legal decisions for you. Our standard form power of attorney, the most typical one we see, is effective immediately. So it says, okay, I, Allison, I appoint my husband, Josh, to be my power of attorney. I get it signed, it's witnessed, it's notarized. Tomorrow, he can take that power of attorney to the bank and close out all our joint bank accounts and sell my car or everything else. I hope he doesn't do that, or else we're gonna have bigger problems. But I point that as an example just to say you don't actually have to be incapacitated for this type of power of attorney to be effective. You say it's effective immediately. And really what you're doing is, okay, yes, I appoint my spouse or my son or my niece, my friend, whomever it is. And the intent is really, you trust them not to actually use that power of attorney until they really need to. But legally speaking, it's effective today. There is a second type of power of attorney called a springing power of attorney, which only springs into effectiveness, and the person you appointed can actually only use it when you actually are incapacitated. So that type of power of attorney does exist as well. Sometimes why I default to saying I kind of like the power of attorney that's better, or excuse me, that's effective immediately, is because with this springing power of attorney, okay, you put a little bit more safeguards in place to say, okay, I don't really feel comfortable just picking someone to serve unless I'm actually incapacitated, so we go with this one. But then if something happens to you and they need to start acting, they do need to get some kind of written evidence from your doctor saying, yes, you're incapacitated. There's an affidavit. Then they need to sign in front of 2 witnesses and a notary to say, yep, we all now agree that this person is now the acting agent. So it's just procedurally speaking, there's a few extra hoops. And yes, it gives you some additional protection there if that's something that makes you a little bit nervous. But the downside is there may be some delay in between when something happens to you and that person can act. I don't put this out there to say don't do a springing power of attorney, because there's certain circumstances in which these I actually recommend and they work well, but I just like to make folks aware of the differences between the two. The healthcare directive, or sometimes these are called advanced directives. I've heard the term healthcare proxy. Each state has its own different terminology for what these are called, but I mean, potato. It's all appointing someone to make medical decisions for you if you're not able to make medical decisions for yourself. Unlike the power of attorney, this is only effective when you actually are incapacitated. Because if you can talk to the doctors and you can answer their questions and tell them what you do and you don't want, they're going to go to you every time. It's only when they feel you don't have the capacity to understand the decisions, or maybe, and again, in estate planning, I always have the worst hypotheticals, so my apologies. You're in a car accident and you're in a coma. There's no way you can talk to the doctors. It's only if the doctors know they can't get a response from you, then they're going to go to the person that you've appointed in your healthcare directive, and they're going to be able to start making decisions on your behalf. A living will. This is the pull the plug language. If I am at the end of my life, if there is little to no chance of recovery, I don't want to be hooked up to all the machines. I don't want CPR and feeding tubes. I want pain medication. I want to be kept comfortable. I don't want my life unnecessarily prolonged. That's the purpose of the living will. It's very similar to a DNR, although it's slightly different. But just really what it's meant to be is a statement of intent for the doctors, for your appointed healthcare representative, as to which care you both do and do not want to receive if it's an end of life situation. Designation of conservator. This is if, or let me back up a second. A conservator is if somebody determines that you should be declared legally incompetent. We need to take away your right to make decisions for yourself. Because even in an instance where you have a power of attorney, you have a healthcare directive to say, if I can't act for myself, here's people who can step in and help, you don't give up your right to make decisions for yourself. You just say, if I need help, here's the people who can also step in and help me too. But there may come a time where you shouldn't be allowed to make decisions for yourself. So again, a lot of my clients who, as they age, develop cognitive deficiencies like Alzheimer's or dementia, they can pick up a phone and they can talk to you, but they might be giving you their social security number. Or they say they pay their light bill 4 times in 1 month because they can't remember if they paid it. So there may be times where we need to have you declared legally incompetent because you're not able to act in your own best interests. If that's the case, there's a procedure where we could go to the probate courts. The courts say, okay, and it's an involved process. They don't just say, oh, somebody says you need a conservator. Yep, you're incompetent. Get out of here. They do require medical evidence. They require testimony. You have to be present. The judge talks to you personally. So like I said, it's an involved process. But if the court ultimately determines that yes, you need to be declared incompetent, that's where this designation of conservator document can come in. It's something you sign in advance to say, in the event I ever get to this point where the court says I need a conservator, here's the people who I appoint. And guess what? it's still my spouse, it's still my kids, or it's still my niece. It's still the same people you want to be in control. And so if it's a time where you're probably not able to say what you want, or maybe not to know what you want, you've already thought about it and written it out in advance, the court has to listen to that. Last but not least is a HIPAA waiver. HIPAA is one of those forms that I don't care if you're going to your dentist, your doctor, your podiatrist. Every time you walk through the door, they shove that form in front of you and say, here, here's a HIPAA, just sign this. HIPAA is a group of federal laws that basically say your doctors can't release your medical information to anybody unless you've told them it's okay. So what they're having you sign every time you walk through the doors generally is more just you're allowing them to submit information to your insurance company, probably so they can submit a claim to get paid. Or maybe they're referring you to another doctor. The HIPAA waiver form that my office prepares in more of an estate planning context is, well, I also want my doctors to be able to talk to my spouse and talk to my kids or talk to my, best friend of 30 years who's bringing me to all my appointments. So this HIPAA waiver form not only allows them kind of general authority to disclose your information to kind of the insurance companies, but to also the important people in your life that you want to make sure they understand what's going on or are going to be able to talk to your doctors and ask relevant questions. What if I don't have incapacity claim documents? Something happens to me and I'm, again, kind of like I passed away and I never got around to doing a will. I become incapacitated and I never actually did a power of attorney or I never did a healthcare directive. As I mentioned before, there's no default decision makers. Not all marriages are created equal. Not everybody wants their spouse making decisions for them. Not everybody's kids are responsible. That's why the state says we're not just going to automatically let people step in and make decisions for you if you haven't spelled out who you want those substitute decision makers to be. So if you don't have a power of attorney and you need someone to pay your bills, if you don't have a healthcare directive and you can't talk to the doctors, you've just guaranteed that you are now passing through that conservatorship process. Because at that point, that's kind of our only option. So somebody has to submit a petition to the court and say, unfortunately, I think mom, dad, grandma is incompetent. We need to have her declared as such and have somebody appointed, the conservator, to make decisions for her now. With that process, as I mentioned before, it can be fairly involved and it can be fairly confrontational. You have to provide, again, you have to get written evidence from the person who you're seeking to have conserved. You have to have a report from their doctors opining, what medications are they taking? What's the diagnosis? Do I feel this conservatorship is necessary? It's kind of this 3-page long report that the doctors have to fill out, has to be submitted to the court. The court then has to have an in-person hearing. The person who filed the petition to say that conservatorship is necessary, they have to come. If you're the person that they're trying to get declared incompetent, you have to come. And the court has to appoint a lawyer for you. Because the end result is, if the court says, yes, you're incompetent, we've just taken away all your constitutional rights, essentially. So the court doesn't do that lightly. So they have to appoint an attorney to represent your interests at the hearing. We then kind of all sit around in a room and unfortunately kind of point at the person who's being declared incompetent and say, they're incompetent. They can't handle their affairs. Does that sound like a pleasant process to anybody? It really isn't. And it can be non-confrontational if everybody's on board and agrees and it was just one of those unfortunate things where the documents weren't in place. But it can be really confrontational. The person who's being declared incompetent can say, I'm fine. I don't understand what this is all about. Johnny, I disown you. You're no longer my son. It can get ugly. So I've been through this process. Again, it can work just fine, but this is not a process you want to rely on. It is infinitely easier to sign that power of attorney in advance, to sign that healthcare directive in advance and say, again, I hope I don't need these, but just in case I do, I already have these people in place. Also, I'll say, even without a healthcare directive in place, I'd be lying to you if I said, if you're rolled into the ER and the doctors are standing there next to, again, your spouse or your kids or whoever there's with you, are they going to look to them and say, hey, we need to do something for your mom here. Are you okay if we do X, Y, and Z? That happens all the time. They're not going to necessarily stand on ceremony and say, we need to see the healthcare directive before we're going to allow you to act. They might. They have the legal right to do so, particularly if your two kids are standing there bickering. They're not necessarily just going to take somebody's word. But I would find more often than not in those kind of medical settings, the doctors are a little bit more lenient and they may still allow decisions to be made. Banks, not so much. They are going to say, if I called up and said, my husband has this IRA, I need to change his beneficiary, never got around to doing it, they're gonna say, put him on the phone. And I'm gonna say, well, I'm his wife. They're gonna say, we don't care, put him on the phone. I'm gonna say, well, he was in a car accident, he's in coma. They say, we don't care, put him on the phone or give us a power of attorney. Any type of financial institutions that you're working with will not do anything for anyone other than you. If it's your account and somebody else is trying to access it for good reason, they say, show us you have the legal right to access these accounts. So again, don't rely on the fact of, okay, well, my spouse should be able to step in and kind of help. Even if you have banks you've known forever or financial advisors you've been working with forever, they're going to say, look, I'm really sorry, but I still need the power of attorney. So I always say think long and hard about if you're doing some estate planning work. Yes, wills are important, but the documents like the powers of attorney, the medical directives are equally as important, if not more so. All right, and that's the end of my slides.
Can we get a hand for Allison?